What happens if you're married, the house is only in your name, and then you pass away? Your house will have to go through the probate process before your spouse can take over the ownership and control over that property. The probate process can take 6 to 18 months depending on the complexity of your estate. And so for that period of time, your spouse will not have any control over that house going through the probate process and have the ability to sell it, to relocate, or do anything like that. And so the reason being is that any assets in your name when you pass away will have to go through the probate process to be distributed out to your beneficiaries. Second layer of the problem here is going to be whether you have a will or you do not. If you do not have a will, that house will be distributed per the intestate laws of your state. As an example, in Georgia, your assets will get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3. And so if you pass away with the property only in your name and you don't have a will, your spouse won't even get 100% over that property. They will have to split it with your kids. And so if you do have a will and you've outlined that that property is going to go down to your spouse, it will still have to go through the probate process, but it will still go 100% ownership to your spouse if that's how you have it set up. And then people will typically have instructions inside of their will that if their surviving spouse, if their spouse is not living anymore, then it would go down to the kids.